Great. All right. Hello, everyone. Thank you for logging in. What I wanted to do today was we had a number of questions. And first of all, please let me know if there's any trouble with hearing. I know we've had some issues on connectivity. So if you have any trouble hearing me, please let me know, either Buzz Chewy or just go ahead and shout it out. So we have a number of questions. Let me answer those, and then we'll open it up. We sent out a letter yesterday. Hopefully everyone's received it, but that kind of sets forth what I think is going to happen over the next few months. We'll get this information regarding the specific documents on Friday. We'll start the preliminary process after that on the 29th, and then on the 17th, the questionnaire will be available online. We can finalize the submissions. It will probably take about 3 months for the first cases to be processed, and then they'll go ahead and start making payments. So that's what we think is going to happen. But obviously, as we go, because again, and I know a lot of people have asked questions, I completely understand about the frustration with how long it's taking. But the problem is, this is a process that's being built from scratch, and so it does take a long time. So that's why it's taking so long. So let's start with this question. The first questions are about attorney fees. And here's the first one. Has the trustee decided what formula will be used for attorney fees? The answer to that is no. Same thing with the next question. How will the final determination be made regarding what method is used to determine attorney fees? And again, we just don't know. The way that it's always worked in the past is, and we discussed this a bit the last couple of times, the Trotter formula. So you would have the economic damages, you'd add 50% on top of that, and then you'd add the non-economic damages. That way everybody would get paid 100% of their economic damages and then get something for having gone through it. Now, the problem is we don't know how it's going to work here. It could be that process, could be a different process. Again, we just don't know. So we're guessing that it'll be something like that. But again, it's completely up to the trustee and how they are going to do it. They just haven't told us yet. To use the Trotter formula, the question was, can you give us a specific number? So here's how it would work. If there were $1 million in economic losses, you would take that amount, $1 million, you'd add $500,000 for attorney fees and costs, then you'd add some other amount for the non-economic damages, say $150,000. That would equal $1.65 million. You'd then take a third of that for attorney fees, which would be $550,000. And so that's how that would work. Again, we hope that's the way they do it, but we're just not going to know, and we won't know until the claims resolution procedures are released. And even then, until we see how they do it, for example, they may say we're going to award attorney fees, but they don't say what the percentage is going to be. In terms of the fee contract and how the attorney fees work with us, it's 1/3 of the total amount recovered. In terms of how much of the attorney fees the trust is going to pay, that's the question that we don't know, and we won't know until we do some of these. Okay, the next question. Are we still looking at 7/29 for finalized claims resolution procedures? We certainly hope so. They told us that the questionnaire is not going to be ready until August 17th. They did say that's a firm date, so hopefully it will be ready on the 17th. I think there's a good chance it will. But 29th, we're hoping to get the claims resolution procedures. If we don't, it should be shortly thereafter, but we will know exactly what we're going to need in terms of documents and information. They say they should have that to us tomorrow. If not by tomorrow, then hopefully by Monday. As soon as we get those, we'll go ahead and circulate them. Okay, the next question. 2 weeks ago, you mentioned that the stock portion of the trust fund was funded with PG&E stock at $9 per share. And for us to achieve 100% payout on claims, this would need to appreciate to $14 per share. As that price target in less than 2 years would be very ambitious for a utility stock, please explain the rationale behind the decision to accept the share price of $9. That's a great question. So again, this gets us back to the deal itself and the pros and cons. And one of the things about this, and this is something that we've talked about for a long time, certainly for several months, is that none of us wanted to be in bankruptcy. It is absolutely categorically not a favorable place for fire victims, for creditors, for fire survivors, anything like that. We do not want to be here. The reason for that is that the bankruptcy laws, and particularly Chapter 11, are designed to favor the debtor, not the creditor. That's the way that it's set up. The problem was, once we're in bankruptcy and we're presented with the various options, there was no good option. There was no option of, if you select this, then we'll be able to get you paid quickly 100 cents on the dollar. There were just two, for lack of a better term, bad options. Option one was to accept the proposed restructuring plan, which called for the $6.75 billion in cash and an amount that was supposed to be $6.75 billion in stock. Although again, that promise was never made. There was a complex formula that was worked out quite some time ago. This is before we got involved. This was a deal that was made between the bondholders and the TCC, and it called for this 14.9 times the net estimated earnings, and then for PG&E to put 20.9% of those shares into the Fire Victims Trust. We're able to negotiate that up to 22.19%. But again, the problem was COVID caused everything to tank. Prior to COVID, PG&E was trading at $15 a share, so the amount that we would have received was about $7 billion. Post-COVID, it dropped and it went down to a little over $9 a share. It's now at $9.50, which is why it increased $190 million. But you know, it's still significantly below the $14 per share that we need it to be in order for it to be that 6.75. Now again, the 6.75 does not mean that we're necessarily guaranteed 100 cents on the dollar for every claim. It may be less, it may be more. We won't know that until it's complete. But the $14 per share is what gets us to the 6.75 billion. So that's why that is the target. We do think it'll happen. At the last Trust Advisory Committee, or the Trust Oversight Committee meeting, the professionals who are the financial people all went through and explained why they thought it would be there. Obviously, it's going to depend a lot on what happens with COVID and with the shutdowns. If the economy is able to open back up and things go back to the way they were before, we would anticipate that PG&E is going to be 15 or above, which would be great for us, but there are no guarantees. And we certainly knew that accepting the stock. But that brings me to the other point, which is the other alternative in terms of not accepting the restructuring offer was that PG&E would go into what is in essence Chapter 7. Technically, it would be Chapter 11 with a trustee who would come in and oversee the sale, but it would in essence be a Chapter 7. And what would happen is all of PG&E's assets would be sold off. So that process would take 2 to 3 years. Typically in a bankruptcy, you don't get anything close to 100 cents on the dollar. Usually it's somewhere between 50 and 75. So in all likelihood, we would have gotten less than we got here, and it would have taken much longer to do it. So that was why we recommended that our clients accept the proposed or support the proposed plan. I understand a lot of people were concerned. I was concerned. I think everyone was concerned. They had every right to be. But again, the problem was there just wasn't a better offer. There were people who said that PG&E, or I'm sorry, the bondholders were offering $13.5 billion in cash. I can say unequivocally that that's false. It's not true. And that was very irresponsible of them to say that. There were other people who said that if we reject the deal, then there will be a buyout by a group that wants to turn it into a municipality. The problem with that, and we looked into this very closely, talked to all of the people who were involved in that, and there was never even an attempt to raise the capital. It was in the very, very early stages where they said, we'd like to do this, but the problem is, and particularly during the recession that we had, no one was able to come up with the $59 billion that was necessary in order to get PG&E out of bankruptcy. So I know that's a long answer, but that was the reason why we believed it was in everyone's interest to accept or to support the restructuring plan. I still think that's the case. I still think it was the right thing to do. Hopefully the share price will go up to 14, 15, and even higher, and we will get more than the 13.5 billion. But if we don't, and we're left with 10 to 11 billion, that still is more in all likelihood than we would have gotten had we rejected the deal and gone with a Chapter 7. And if we did the Chapter 7, it would be 2 to 3 years. So it's happening much more quickly. Okay, next question. Are the mediators prepared to go day one upon trustees' offer, or are they going to be caught off guard as well? So I think it's important, and again, we don't have the final claims resolution procedures, but I think the question here is, are they going to be ready to process the claims? The answer is yes. Again, what's going to happen though is that while they're going to begin processing the claims immediately, they're not going to begin making offers until they've processed a significant number. Essentially what they want to do is get an idea in general of what they're dealing with, formulate a budget, then make the initial offers, and then we'll go from there in terms of what happens next. The initial offers, once they're made, you can either accept them or reject them. If you reject them, then, and we know this part of the claims resolution procedures, there'll be a two-step process. You can immediately go before a neutral, and that will be available immediately. Or you can, if you don't like what happens with the neutral, then you can go ahead and go to arbitration and have it decided there. If you don't like that result, then you can appeal directly to the trustee. So that'll be the procedure. Next question. As far as what charity, how about putting it back in the trust? I think that's a good idea. And that's certainly something that I would be in favor of. We'll have to see what happens. Ultimately, that's up to the trustee and to Morgan Stanley, but it will either go to a fire survivor charity, or it will go to back into the trust. What are the trustee and claims admin hours of operation? That I don't know. I can certainly find out. Typically, it's going to be normal business hours, but that's something that we can find out and let you know. Next question. Please explain what is in the questionnaire that is taking months, and when can we receive a copy? So again, August 17th is the date that they say is the firm date, and it will be available on the portal. It's not going to be in a written format because it has options. For example, it's one of those where if you say yes to one question, then different things will pop up. Whereas if you say no, then it'll move you on to another section of questions. So that's why I don't think there will be a hard copy. We'll certainly see if we can develop one. If we can, then anybody who wants it is welcome to get a copy. In terms of why it's taking so long, I don't think it's necessarily the questionnaire that's taking so long. I think the problem they're having is that the trustee and the claims administrator are in this position where they're having to disseminate and distribute the largest amount of money that's ever been involved in one of these types of cases. And it's a daunting task, and they really don't want to make any mistakes. Because of that, it's taking them longer than it might otherwise. If it was a much smaller case, or if it was an unlimited fund and they didn't have to worry about exceeding the amount, then I think this would be a lot easier. Next question. How do I submit charities for consideration? Just send us the name and we're happy to send it to them. It says, are churches a consideration, old theater restoration? I think the answer to that is probably no. I think, and this is just based upon the initial conversation that we had yesterday with the trustee, but my understanding is they're going to try to give this to fire survivors. So, you know, for example, an example might be Coffee Strong, for example, in Santa Rosa. Coffee Park neighborhood, I'm sure everybody knows, lost a large number of houses, well over 1,000. And so they formed a group called Coffee Strong to help other survivors. I think that's what they're thinking of. And I don't want to say that it's only going to go to Santa Rosa or Sonoma. I would like to see it obviously go to all of the different areas. But I think that's the kind of thing they're looking for. They're looking for charities that directly benefit the survivors. So anything that you have along those lines, please let us know. Okay, the next one. Please address the following editorial in the Santa Rosa newspaper regarding Kincade fire strategy. All right, now that PG&E has successfully emerged from Chapter 11 bankruptcy, the victims of the 2019 Kincade fire have strategically waited to file a lawsuit against the company for the devastating loss of their homes, possessions, and damaged property. For the rest of us, the victims of the 2017 North Bay fires, as well as the 2015 Butte and 2018 Camp Fire, it's another game entirely, likely to evolve into a, quote, Mad Max Thunderdome, end quote, scenario where thousands upon thousands enter, but very few leave. After overwhelmingly approving the $13.5 billion victim trust, any plain reading of the trust agreement and claims resolution procedures makes it abundantly clear that any fire losses covered by insurance will be deducted from any claim against the trust. In other words, no double dipping allowed. For those who bothered to carry sufficient insurance coverage and showed the grit and determination to rebuild their homes, the best they can probably hope to get for their pain and suffering will be a $100 gift card. At the end of the day, I suspect the Federal Emergency Management Agency will get the piece of the fire victims' pie it so desperately wants. So, you know, obviously strong feelings there and understandable. Couple of things. Let me kind of take it from the top. The Kincade fire is different. That is not going to be part of this trust. So the amount of money in the trust will not be depleted. It will be dealt with separately. PG&E has insurance to deal with Kincade, and if it exceeds insurance, then there is the money from AB 1054. In terms of the statement about no double dipping, that is true. Now, I do want everybody to understand that it's the same no matter what. So in all the fire cases I've handled, and this is the first one that's gone into bankruptcy, they have never allowed that. The way that it typically works is that you have, on the one hand, the subrogation insurance companies, and then you have the individual plaintiffs. And the subrogation insurance companies sue to recover the money that they pay the individual plaintiffs, and then the utility, whether it's PG&E or somebody else, pays them back. So the reason that, you know, for lack of a better term, double dipping is not allowed is that you can't force a defendant to pay twice. You can force them to pay the money, but if the subrogating insurance companies are paid, then we can't force them to pay the same amount of money to the subrogating insurance companies and to us as well. And that's true whether it's bankruptcy or not. In terms of the amount of pain and suffering, obviously, I don't think it's going to be a $100 gift card. I can guarantee it's not going to be as much as you would get if you went to trial, but that's always the case in settlements. The reason that defendants settle is that they get a discount, and it happens much more quickly. So that's what we're going to be looking at. We're going to be looking at the settlement value, whether that's, you know, $25,000, whether that's $50,000, whether that's $100,000. We won't know what it is until the trustee is able to look at a significant number of claims, develop a budget, and then do it that way. And then obviously, it's not going to be the same amount for each person. If someone is exposed to danger as a result of the fire, as opposed to being able to get out early, or being out of the area when it happens, then they're going to recover more. Similarly, if you had lived in your home for 30 years and you had a lifetime's worth of memories, that's obviously going to be worth more than if you just moved in the prior week. If you lost, again, a lifetime's worth of cherished possessions and you had a large number of significant things, for example, maybe the flag of a relative who passed away serving the country, or, the ashes of a loved one, photographs of deceased loved ones, that's going to be worth more than someone who was able to get those out and didn't lose them. All of those things are taken into account, and that goes into the final determination in terms of what everyone receives. Finally, in terms of FEMA, the one thing that I can promise is that FEMA is almost certain not to get anything. The only way they're going to get anything is if the trust is able to pay everyone's claim 100% and to pay punitive damages. Then, if there's any money left over, it goes to FEMA. I can't say the sun is going to rise tomorrow, but I can say with a great deal of confidence that there will not be any money left over after the trustee and the claims administrator are done distributing it. So I think that is very unlikely. So that is at least one thing that fire survivors are not going to have to worry about. Okay, those are the questions that we have. Chewy, do you have any that are that were sent in?
Yes, I have a few here on the chat. The first one is, we plan to rebuild. Our son is helping us since we are out of state. He's on our property. We are being told that because he is not the owner, he has to move. If we put his name on our title, will that jeopardize our claim?
No, it won't. You are still the owner. You still have the right to recover. The way that it works is the person with the right to make the claim is the person who owned the property at the time of the fire. Now, if you were to sell it, in other words, if you were to either sell it to your son or if you were to do a transfer and deed it to your son, now you would no longer own it, so you would no longer have the right to recover the cost of cure. But if you were to simply to add him on, then that's not going to interfere with your rights.
Thanks, Jerry. Another question is, what specifically does Morgan Stanley have the power to do with the stock, and when?
The only thing they have the power to do is what the trustee instructs them to do. So they were retained in order to come up with a strategy for selling off this stock. One of the things that I learned yesterday on this call is that this will be the largest utility stock offering in history. There's never been one where this many shares have been sold. And so because of that, Morgan Stanley has to devise a way to sell these shares without tanking the price. And the financial analyst took us through it yesterday, and he said, look, after 90 days, we can sell up to the full amount if we want to. However, if we were to do that, we would drive the price from 9.5, which is where it was at the time of the call, down to maybe 6, which wouldn't be in anybody's interest. So the way they're going to do it, first of all, they're not going to sell any stock until they have to, until they've run through the $5.5 billion in cash that they have. And they want to see if they can wait, ideally until after the announcement of the net estimated earnings from next year, which should happen in January or February, because if those are up, then it'll cause the stock price to go up and the stock will be worth more. But even when they do start to sell, they can't sell, in blocks of 100 million shares. They're going to have to sell small amounts, or to work out some way where they sell huge blocks to institutional investors so it doesn't affect the price of the stock in trading. As the guy told us yesterday, we can't just go on E-Trade and all of a sudden say, we've got 479 million shares of stock we want to sell. They've got to do it very carefully. Morgan Stanley's job is to do that and to maximize the value to the trust. So the trustee has investment bankers that advise him, and that's Houlihan Lokey. And then you have Morgan Stanley, who are the traders, and they are the ones that are going to be doing the actual trading of the stock. That's my understanding based upon the briefing that we received yesterday. We're supposed to receive more briefings over the next couple of months, and obviously nothing can happen until the earliest September 27th, which is the end of 90 days. So we've got more time to understand how this is going to work. But my understanding is they are going to wait as long as possible to try and get the stock price up as high as they can.
Thank you. Another question here is, will we have access to the portal, or will the attorneys be the only ones entering the questionnaire info?
Usually it's the attorneys. There's not really any reason that an individual would need to have access. And we do want to make sure that the information that we present is the way that we want it to be. If there's an extraordinary reason, if somebody wants to do it, then we can certainly arrange that. But typically the way it's done is that the attorneys are the ones that submit all the information to the portal.
Okay, another question is, one sec, sorry. We've heard that some people are getting offers now, settlement offers. Others are insisting that this isn't the case. Can you explain?
Yeah, that's not the case. There's a few cases that there's two groups of cases, two very small groups where the numbers are determined. It's not that they're receiving offers, but their numbers are already determined. And here's why. In Butte, in the 2015 Butte fire, there were 52 households that had settled, had signed fee agreements, but had not been paid when PG&E declared bankruptcy. So those poor folks went from being about to get their money in January of 2019 to having to wait until just now. PG&E just paid those. We received the check yesterday. So those people are getting paid, and that may be some reason for the confusion. There's another 18 cases that were severed off from the bankruptcy case, and the stay was lifted so that they could go back to Superior Court and we could try those cases. And this was in September of 2019 when we were going back and forth about the estimation procedure. And the court in the bankruptcy said, it would help me if I had some verdicts on these. So, I'm going to have 18 cases that I send back, and those cases are going to be tried. Those cases ended up settling in December of 2019, but those 18 cases have their numbers determined. Other than that, no one has received any offers, and that won't happen, according to the trustee and based on our conversation yesterday, for at least 3 months.
Thank you, Jerry. There's a follow-up to the question about adding the clients adding their son to their title. So if they do that, would that allow him to stay on the property as co-owner?
I mean, I'm not a real estate or real property lawyer, but and you'd have to look at obviously the circumstances. But if the rule in that particular municipality or county is that only owners can be on the property while it's being built, and he's an owner, then you would think he'd be allowed to. However, I would definitely check it, because if you're just relying on what somebody says, if they say, for example, he can't stay on here, he's not an owner, it may well be that even owners can't stay on there legally. And so I would want to check that before I went through all of the trouble and expense to add him on.
Thanks, Jerry. There's a follow-up to it. It says, you mentioned that as soon as claims are sent in, the trustee will develop a budget. How many claims must they receive before determining that budget?
Yeah, that's a good question. It's not really clear. I mean, basically, they're trying to, they're doing it as they go, but there are a large number of claims, about 25%, that they have no information on. So they want to get as many as they can so they have an idea as to what the overall budget is going to be.
Thank you. I have one more question here in the chat, and it says, what was the total for the Butte payout, and why were they paid now?
Right. That was, I'm trying to think. There were 52 cases, 30 of them were ours. I believe the total amount was $9.8 million. I could be mistaken, but the reason they were paid now is that they were not part of the trust, because there's two types of claims in bankruptcy. There are pre-petition claims and post-petition claims. A pre-petition claim is a claim that is finalized prior to declaring bankruptcy. A post-petition claim is obviously one that accrues after bankruptcy. And the way that the court ruled in this case is that if there was a settlement agreement, that was considered a pre-petition claim. Because of that, that 9.8 million does not come out of the trust. It comes out of PG&E general operating expenses. It's completely separate and apart. And so those cases were considered pre-petition. They have nothing to do with the trust, and that's why they were paid immediately upon PG&E emerging.
Thanks, Jerry. I don't have any more questions via email or the chat. We can open it up.
All right, who's got questions?
Hi, Jerry.
Hi, how are you?
I'm good. How are you?
Good.
Thanks for all your talking.
Sure.
Okay, I just can't wrap my mind around this insurance thing. I know that they're not going to double pay, and if your insurance company potentially, let's just talk about additional building costs. Potentially, I might have $62,000 coming in additional building costs. Now, if I don't rebuild and they don't give me that money, and I don't get that money, PG&E settlement's still going to deduct it. It doesn't make sense to me.
Here's why. Remember, there are two different ways of calculating what your real property losses are. The first and the most common, the standard one, is diminution in fair market value. So they look at the value of your property the day before the fire, let's say 500, and the value of your property the day after the fire, let's say 100. That $400,000 difference is your diminution in fair market value. However, there's a second way, and this is where we try to get our clients because it's more beneficial to them, and that is the cost of cure. And that can exceed the pre-fire value, the same way that if you have a car and you chop it up and sell it for parts, it's going to be worth more than the whole of the car. Same thing here. So if you were to look at the cost to rebuild your home, the cost to redo the landscaping, the value of the trees, the value of the outbuilding, value of the hardscape, it's probably going to come out to more than 500. Using that example, it would probably come out to 600,000-700,000. So if we're going to ask for that 600,000-700,000, we can do that. But the thing about cost of cure is that you have to have an actual intent to rebuild your home. So the way that the trust is going to look at it is they're going to say, okay, you've told us that you intend to rebuild your home, and that's fine. We believe you. We will allow you to use that heightened standard, the cost of cure, which will give you an extra 100, 200, maybe even $300,000 over the diminution in value. However, because you're using that standard, we're going to assume, because you said you were going to rebuild your home, that you're going to receive that extra $62,000. And that's why they do it that way. You're still going to get more, but because you've elected to proceed using a method that requires you to rebuild, they're assuming that you get the money from insurance that they would owe you if you did in fact rebuild.
Okay, well, that makes a whole lot more sense now. Thank you.
Sure,
one
no problem.
quick question. Now that the Butte fire has settled, what is this like in a ballpark? Some of the pain and suffering that PG&E paid them for complete loss of their house?
Oh, well, remember, that was different. This had nothing to do with the trust. So those cases were all different. And there still are a lot of Butte Fire cases. This was just I think we had 32 cases. Some of them were small, some of them were soot and ash, some of them were complete home losses, and they varied, in some of them it was 150, in some of them it was much less. Obviously if your losses are smoke and soot, you're going to get a lot less than if you were, say, a complete home loss.
Thank you.
Sure thing. All right, who's next?
Hi, Jerry. I have a question.
Okay, go ahead.
How you doing?
I'm good. How are you?
Good. I'm good. Thanks. Hey, I'm in a group with some of the campfire victims, and I've seen this a lot, and I'm wondering myself, when it comes to our losses sentimentally, like for your mother's ashes, for your son's urn, maybe this was addressed before, I just don't remember. How are we coming up with a figure, or do they expect us to, or how do we do this?
No, and that's a good question. Those are really the by far the hardest thing to value. And what we've always done, and what the trustee has asked us to do this time, is just list what they are. So we will list what we call them cherished possessions, what the cherished possessions are, and then they will factor that in to the non-economic damages award. So when they're coming up with your non-economic damages award, they'll look at three factors: cherished possessions, your proximity to the fire, and then what happened. You were one of the lucky ones and were able to rent a similar home, and your style of living didn't change much. That's one thing. On the other hand, if you were less fortunate, if you were in unstable housing, if you went from living in a comfortable 3-bedroom house to a 1-bedroom apartment, all of those things are things that are factored in. Those three factors: cherished possessions, proximity to fire, and how the fire affected you, are going to be what they consider in determining that non-economic award.
Okay, that makes sense. That takes a big load off of our minds. Thank you.
Yeah, no, understood. Okay, who's next?
I have a question regarding Morgan Stanley selling the stock. Will they be getting a commission, and where will that commission come out?
Yes, they will be getting a commission. I don't know the exact numbers. That's going to be part of the next what they normally offer. But again, these are part, and this was something I think we talked about 3 or 4 times ago. These are all part of the trust expenses. We pay the trustee, we pay the claims administrator, we pay the neutrals, we're going to pay Houlihan Lokey, we pay Morgan Stanley, we pay all these people. The goal, and I think this will come out, the goal is for all of that to be paid out of the amount of money that we receive from the third parties, because, as we discussed, we're also suing the contractors, and we think we're going to recover hundreds of millions of dollars there. The goal is for everything to be paid out of that, and then hopefully there'll be some left over that'll go into the trust, but at minimum, all of the expenses will be paid out of that.
All right, thank you.
Gary, I do have a few more questions here on the chat.
Sure, go ahead, please.
It says, since we had to move out of state until we can rebuild, we incurred expenses for repairs to the house we bought in order to comply with homeowners insurance. Can we claim these expenses as ALE that we had to pay out of pocket?
That's interesting. I think it depends. If it's temporary housing and you have to make repairs, I think you can claim it. If it's permanent housing, in other words, if you bought the home, I think the answer is no, because you've improved an asset that you own. And so I don't think they would consider that ALE. Wouldn't hurt to list it, but my guess is that would not be allowed.
Thanks, Jerry. Another submission here. It says, I had a car on the property that I was renting in Paradise. It was stolen before I was able to remove it from the property. Is that something I can include in my claim?
Yes. Unfortunately, as I'm sure many of you know all too well, looting is very common in these types of fires. In fact, for a while, there was kind of a cottage industry. Wherever these fires would happen, there would be groups of people who unfortunately would sneak in and would start stealing things. This is one of the reasons that they passed the ordinance which prevented people from going into these zones. It wasn't to prevent homeowners from going back and protecting their property. It was so the sheriffs and other law enforcement would be able to identify looters, and they could preclude people from going in. That way, if there was anybody there, they would say, okay, show me your identification. If you can't show me a driver's license or some other indication that you live in one of these places, then they would be arrested. So it's kind of a long way of saying, yes, anytime you have a loss due to a theft that happened after the fire, as a result of the fire, which, you know, looting or a theft of a car that was on the property would be, you can definitely claim that.
Thank you. I have a question here about homeowners insurance costs. It says, can we claim the increase in homeowners insurance costs? If so,
Yes.
for how many years going forward?
Yeah, sorry about that, Joe. I didn't mean to interrupt you. Yes, you absolutely can. Typically, we claim it for 3 years because that's the normal insurance cycle. They usually tend to reevaluate after 3 years. But I have seen it claimed for as long as 5 years if there's a specific reason for that. So I would say definitely claim for 3 years. And if you want to try and claim for 5, that's fine.
Okay, and one more question here is, what were the payouts for the Tubbs cases?
The payouts. Now, I want to make sure I understand. If the question is, what were the payouts for the 18 cases that settled, the preference cases, the settlements were confidential, the same way as all these will be confidential. They were in line with prior settlements. So, you know, for example, we'd settled about 1,000 Butte cases prior to PG&E declaring bankruptcy. All those are confidential, but the formula that we used to settle the Butte cases is the Trotter formula, which is the same one that we used to settle the Tubbs cases. So in my career, when we settle fire cases, we use that Trotter formula. In something like this, where it's a trust and it's basically, I don't want to say dictated because that's the wrong word, but it's going to be decided by the claims administrator and the trustee, it is up to them. So that's the difference. I can't guarantee that these settlements will be the same as the ones in the Tubbs. I think they'll be comparable, but again, I only know the answer for the 5 that we had in Tubbs. There were 18 total cases. 5 of them were clients of mine. I can't say for the other 13, but my understanding is they were all settled according to the typical way these cases are settled.
Thanks, Jerry. There's a follow-up. The person who submitted one of the earlier questions via email is wondering if you can sorry, Jared, if you can discuss the Trotter formula. And,
sure.
And if, again, the question was initially answered, but it was about, has that formula or that method been decided in this case?
Right. So it hasn't been decided. We don't know what criteria they're going to use. The Trotter formula we named that after Justice Trotter because he's the one that came up with it in the San Diego fires, and we've always used it. But basically what it is you figure out what the agreed upon economic losses are. And these aren't the economic losses that the plaintiff submits. I mean, typically we come in high, defense comes in low, and we meet somewhere in the middle, and that's the economic damages. Once we agree on that, then we add 50%, and then on top of that, you add something for having gone through it, the non-economic damages. So again, to use the example from earlier, if you use $1 million for economic damages, you'd add 500 on top of that for fees and costs, and then you'd add another 150 for having gone through it. That would be 1.65. A third of that is 550. So that would leave $1,050,000 for the plaintiff.
Thanks, Jerry. I have a follow-up here in regards to the homeowner's insurance. You said, what about the Butte survivors insurance increases? Do they get to go 5 years back and 5 years going forward?
Yeah, I mean, what I would do if we're talking about specifically Butte, once your insurance goes up, then you factor in the new one, and if it's still there, then I would project it for another 3 to 5 years out from this point.
Thank you. Looks like I have a question from Mr. Persons. Go ahead.
Okay.
Yes. Hello, Jerry. Nice to see you again.
Good to see you.
You explained the Trotter formula. Now, is that decided on an individual claim basis or the total claims?
Right. That would be an individual claims basis. And again, I don't want to give anybody the wrong idea. That's what we've always used in the past, but the trustee and the claims administrator are coming up with these formulas, and they're going to decide exactly how it happens. Now, obviously, if we don't think the offer is fair, we don't have to accept it. We can move to a neutral, we can move to arbitration, and the arbitration would not be with either the trustee or the claims administrator, it would be with another neutral. So we'll have that opportunity.
Oh, okay. All right. Thank you. Thank you.
Sure.
I have looks like Michelle Nixon.
Hey, couple of questions just came up. When
Sure.
I was wondering, I know somebody brought up just a minute ago about paying for, I forget what they were discussing, but I was thinking about all the times we've had to move and paying for some of the things several times and being able to claim them because we've been in different homes and we've had to leave some things behind because of having to move fast because of black mold. Can we keep claiming all those same things since they were all temporary dwellings?
Yeah, I think as long as, I mean, the touchstone is.
I can't hear 'em.
Hey, Jerry. Looks like a bad connection there.
Related to the fire.
Is
So,
it Jerry's connection or mine?
Can you hear me now?
A
Yeah,
little
that's better, Jerry.
Okay, yeah, you broke up. You were going really slow.
Okay. If you had to move because of the fire,
Yeah.
then I think you're going to be okay with claiming that, even if you had to move multiple times, because it was unavoidable and it was a result of the fire. That's the way I would look at it.
Okay, and also I wanted to ask one more thing. The things that were listed in our taxes for last year, a lot of that list wasn't as thorough as it is now that we're having more time, but we had to do that for my tax lady. Do we have to submit that list, or can we submit that and then add on to it when we're listing down all our property losses, or how does that work?
Yeah, you don't have to list anything. So if you're, for example, if you listed something on your taxes, but you don't want to list your entire tax filing, you certainly don't have to. You can just give us the list, and we only need the final list. So you're not required to submit your tax returns. You have an absolute protection on that. So I would just put together the list and then submit that.
Okay, and on one more thing, if we get to a point where the trustee doesn't have enough people, putting in their claims, will you send out something so that we can get enough people so that she can figure out what that amount is so we can get the claims going?
Sure, but I don't think that'll be an issue. We're going to be submitting a lot, so I think that'll happen. I think the biggest thing is going to be what happens with the stock. I think that's going to be a huge issue they're going to be looking at that. But in terms of processing the information, I'd be very surprised if we didn't get a ton of things submitted very early, and if we weren't able to make initial payments before the end of the year.
Okay, perfect. All right, thank you.
All right, Chewy, who's next?
I don't have any more.
I would like to.
Please, go ahead.
Hi. I have a couple of questions now. I'm forgetting it. Okay. Number one, with the insurance, we paid, that was a contract between us and the insurance company. You pay us this premium, we will cover you in case of a loss. So we pay the premium year after year for 50 years, and then we have this absolutely massive loss. Okay? Then of course they do their thing. Why should they be ahead of us to get paid? You know, they were in a business, that was their business. They took that risk, they took that loss. But the company has paid them before they're paying us. And that doesn't seem right. That whole system doesn't seem right. We should have been paid if anything is left over, then reimburse the insurance company, right?
Right. There's a couple of things there. Number one, they weren't paid before the individuals. Everyone was paid at the same time. The difference is because they accepted a substantial reduction, they're getting paid 57 or 58 cents on the dollar. They received cash as opposed to cash and stock, liquid. I mean, they know what their damages are because they paid them. With the individual, quantify the damages for each person. So that's why the insurance companies have received their money, but the individuals haven't been paid out on an individual basis, although PG&E has funded the trust. The other thing, and this is where I could not agree with you more, there is an equitable doctrine called the made whole rule. And it used to say that insurance companies, as you said, could not get paid a penny until their customers were made 100% whole. Unfortunately, insurance companies started putting in their contracts waivers of the made whole rule, and those were upheld. So the made whole rule now has very little power. And in general, insurance companies are able to go ahead and recover the amount they pay, whether or not individuals are made whole.
Okay. I did not know that. My other thing is, and you know, don't laugh at this, but it seems like the new CEO of PG&E was in court in paradise and agreed, took responsibility for the deaths of 84 people or as many as they died. You know, it seems like the directors, they have really not paid anything. I would give up a whole lot of my money, my settlement, to have a bunch of them have to stand on busy corners once a week for the next 10 years saying, I was responsible for the death of, you know. It just seems like they're getting off without any real punishment. And these are the ones who call the shots, which caused this fire.
Well, you know, first of all, I couldn't agree with you more. I mean, one of the problems we have with the way that corporations are structured in the American economy is they really do have immunity for things like this, as long as they can contend that it's negligent. And obviously it's different if there's a deliberate decision made where, you know, they deliberately harm someone. But as long as they can say it's negligent, then when this happens and when people are harmed, the individuals who make the decision that it, for lack of a better analogy, set the chain in motion, where this happens get off scot-free. And you know, it goes without saying that no one wanted this to happen, if for no other reason than they don't want to lose the money. But by putting the policies that they do in place and by placing profits above safety and everything else, the people at the very top create a situation where the type of negligent inspection happens that leads to these kinds of fires. And that's a problem that unfortunately is as old as corporate America. And you know, if we were to design a different system, frankly, I think there's a lot to be said for it. But as long as we have artificial human beings that are called corporations, and the individuals who make these decisions have immunity from liability, and for the most part, criminal liability as well, there just isn't a way to hold them accountable. What happens is what happened here. When you have somebody like Geisha Williams, who was the CEO for these fires, she gets fired, gets a golden parachute, and there really are no consequences. I think that's fundamentally wrong, but unfortunately, it is a broader problem, and it's not unique to PG&E. You know, you see it all over the place. There's so many instances of malfeasance in corporate America. You know, it's a problem that is unfortunately inherent in the system.
Thank you.
Yeah.
I have a question from Michelle Nixon.
Yeah, go ahead.
So Jerry, a few people have said that they've been contacted to give their statements and their story of, you know, evacuation, whatnot. Does this happen after we turn in all our information, or are people being contacted even before we've submitted everything that we need to?
Well, typically the way we do it is we have the narrative be the last piece. So if we have everything else and we're ready to submit, then we'll get your narrative and then we'll go ahead and submit. That said, you know, if somebody wants to do a narrative now and they're not ready, no problem, let us know and we can do it. But unless someone expresses that preference, that's the order we usually do it in.
Okay, thank you.
I don't have any more submissions here, Jerry, via email or the chat.
I do.
Go ahead.
One more thing. This question was asked the last time by somebody who said, why can't we be paid in PG&E stock if it's so depressed? And you said it wouldn't be fair to everybody. But it seems like if you're ready to be paid and they're selling the stock, and I say you're selling it at $8, give me that stock, you know, rather than, because we know whatever they say, when you put out hundreds of millions of dollars of stock, the investors are not stupid. You know, the price is going to be down. I doubt it's going to come up. But if you wait for a few years, it will come up with all the goodies that PG&E has gotten from the state. So, you know, it seems like it would be nice if people had the option of, because everybody's going to take a huge discount. You know, their claims are not going to be paid 100%. I'm getting that feeling because there's a lot of claims and there's a limited amount of money which can even go lower because of the stock price. So why can't something be, you know, figured out so people have the option of taking it in stock?
Sure. You know, first of all, obviously, we're hoping that the stock appreciates so that people are not having to take a discount. But the answer to your question is that actually myself and a couple of other people, a couple of other attorneys pitched the trustee and asked that individuals be allowed to have the option of taking stock. The trustee decided that it was not something they were going to do. And my understanding is the reason is they were concerned about what would happen if the stock went down, liability, issues like that. And basically what they were saying is this: if we do that and if the stock goes down, we're going to be sued and we're going to have to spend money defending the suit, which is going to come out of the trust. So their theory, and rightly or wrongly, is that we're going to give people cash if they want to buy PG&E stock so that they can ride it up. They're more than welcome to do that.
Okay.
Thanks, Jerry. There's a question from Anthony Spencer.
Sure, go ahead.
He just submitted it via the chat right now. It says, I had to buy a new car due to the damage to my cars. Do I get reimbursed for the new car as well as the one that was stolen?
No, the way that it works is you wouldn't get reimbursed for the new car. You would get reimbursed for the fair market value of the damage to the old car. In other words, if the damage to the old car is 10 grand and you bought a new car for 12, you would get reimbursed for the 10, but not for the extra 2.
Another question here is, why do we have to pay for the arborist? For expert, let me see. Why do we have to pay for the arborist?
The experts that we use are for each individual case. So if you have damages to trees, then we'll need an arborist. If you have erosion damages, we'll need a hydrologist. Structure damages, a contractor. We hire the specific experts that are necessary to work up your case. And the reason is we want to maximize the value of each person's case. And the only way to do that is to have the right experts.
Thank you, Jerry. That was the last submission here via the chat.
Okay.
Jerry, can you hear me? I have a question.
Yeah, go ahead.
I lived in Magalia, and going back down now, every now and then, because now we live in Oregon, it's very depressing down there. All of it is. Yeah. But we do want to rebuild right now. What happens if at a later date, when this gets solved and we find out how much we're going to receive, going down and finding out what it would cost for replacement, what if we change our mind at that time and decide it's just not where we want to be for the rest of our senior days?
No, understood. And that's frankly a position a lot of people are in, which is that they'd like to rebuild if they can do it and it makes economic sense, but obviously they're not going to make a foolish decision, particularly later in life. The bottom line is, all you have to be able to say in order to recover the cost of cure is that you'd like to rebuild. And that's what you intend to do if you can. If it turns out that that does not work for you, then, that's fine. That's just the way things go. The only time you can't claim cost of cure is if you know you don't want to rebuild, or, you're very unlikely to. If you say, look, frankly, I just don't want to rebuild. I'm not saying I never would, but it's not what I believe I'm going to do. In that instance, you would be limited to diminution of value. You have to have the ability, meaning you have to still own the property, and the intent in order to claim cost of cure. But if you change your mind later on, that's fine. There's no consequences for that.
Okay, thank you so much.
Sure.
Hey, Jerry, there's a question from Miss Susan Craig.
Okay.
Yeah, hi, Jerry. I have a question. I've submitted all of my paperwork, and the person from your law firm, who's my case manager, or whatever you call that, said that he hasn't received the letter from my insurance company that my case with them has been closed, although it was closed 2 years ago. And so is this common for insurance companies, even 2 years after I completely closed with them, that they don't get you the paperwork?
Yeah, unfortunately, insurance companies are not any easier for us to deal with than they are for all of you to deal with. I know some people had great experiences, and that's wonderful, but the lion's share of my clients certainly have not had wonderful experiences with insurance companies, and they're the same way with us. So we demand the files, we ask for the files, and some they give us, some they don't. So we keep the process, we keep the pressure on. When they're slow in getting stuff, we'll go to court, and that always gets them moving. So we will get it. It's just, unfortunately, sometimes it takes time.
But they don't get their money until they've given that to you, right?
They don't get their money until they submit it, but the way it works is they'll submit it to the clearinghouse, Brown Greer, and then we'll get access from it from Brown Greer. So they have an incentive to do it, but
Okay.
Unfortunately, again, it does take them some time.
Okay, all right, thank you.
Sure. Chewy, do we have any other questions?
I'm gonna check the chat. Says our case is not closed with Allstate, as we are still waiting for Butte County to send us their bill for general debris removal. Is that a problem?
No, debris removal, because it's limited to, in terms of the contract you signed with the whoever was managing the program, and it's different people in different places. Typically it's the county, but sometimes they do it directly through the state. Whoever was managing that program is just going to take the amount of the insurance. So that's not an issue because we won't be claiming that. We'll be claiming the other losses. So no problem there.
Thank you, Jerry. That was the last question here on the chat.
All right. Any other questions before we wrap up?
One more. Hello?
Oh, yes, go ahead.
Yeah. So debris removal, they did not remove the trees and, all that stuff. They did not take down the trees. That was under insurance, and my insurance paid very, very little on that.
Right.
So I can turn in those bills, right?
Oh, absolutely. Yeah. Any additional debris removal.
Yeah.
I'm just talking about the amount of the insurance and what the bill is from, for example, Butte County, or in your case,
Mendocino.
the county of Mendocino. It doesn't matter what their bill is because they limit it to the amount of your insurance.
Yes.
So that's completely separate than what we would be claiming.
Okay. Thank you.
Jerry, I got a quick one.
Yeah, go ahead.
On as far as removal goes, now as far as the trees, they haven't even, in Paradise, it's a mess up there. They haven't even started doing the trees, and we signed a right to enter form, and I think they're getting $8,000 from my insurance. They haven't started taking them down, and when they do take them down, what about all the stumps?
Yeah, typically they don't remove the stumps. Typically they leave them there. So usually what will happen is our arborists, when they do the report, will factor in what it's going to cost to remove all of the dead and dying trees.
The stump and everything. Okay, thank you,
Yeah,
Jerry.
that'll be everything.
Okay, thank you.
Sure. All right, any other questions? Okay, so let's plan on doing it again next Thursday. Hopefully we will get this information tomorrow. As soon as we do, if it's tomorrow, we'll forward it out. If it's Monday, we'll do it then. Again, we're moving forward. I know it's taking longer than everybody wanted, but we want to make sure that this is done right. And the last thing we want is for the trustee not to get it right the first time and then go back and have to do everything again. So please let me know if you have any questions, and take care, everybody.